the athletes
Right.
or the schools. So there's that.
Right.
And then secondly, the recruiting aspect that was talked about. Now, we could do the state-by-state free market approach, and states could jockey with each other to make the most athlete-friendly laws. And hey, look, with sports betting, that's what's happened. With other industries, that's happened. But I do think once we go the state-by-state approach, the door's shut. It's going to be very hard to get back in once states adapt their own rules and become accustomed to them.
Among the states that have enacted the NIL legislation, Nebraska included a provision that is giving flexibility for colleges and universities to adopt the NIL rules early if need be. President Frederick and President Emmert, I'd like to focus on universities' roles in the NIL conversation. Would you both please comment on how universities can ensure compliance and help our student athletes navigate this really complicated landscape of state NIL laws, NCAA rules, and institutional policies, please?
Yeah, we will certainly have to do so with great difficulty, because every time we recruit a student, depending on what the setup is, we'll have to look at that. And I think it's akin to having a seatbelt law that's different in 51 states. Somebody driving from New Jersey to North Carolina can take their seatbelt off on the way and have different laws, and I don't think we want that. So doing it with different state laws is going to be difficult. And then if you are in a state or the District of Columbia, as Howard is, trying to assist with recruiting compliance around these issues while recruiting athletes is also going to be very difficult. The other concern, the last concern that I have is like pro sports, when athletes do compete in different states, they are subject to tax laws, as an example. Would there be loopholes in the law that allow NIL, even if you're in a state that doesn't have it, for the athletes that are competing in conferences that may be going to multiple states? And I think that when we talk about lawsuits that could be filed, we are risking an opportunity there for having loopholes where people may begin to file lawsuits because they're being denied an opportunity for NIL because the state does not have a law that's passed.
Senator Fisher, I think you put your finger on one of the most important reasons for having a national standard, and that is the difficulty that individual athletes, individual recruits, individual schools and coaches, compliance officers on the campuses will have in trying to navigate all this catchwork of policies and rules. Imagine an athlete that Coach Few might be recruiting. That athlete is looking at multiple schools in multiple states, and maybe an international student. They would have to pause and think about, as Dr. Frederick said, the tax implications in one state versus another state. What does this all look like and mean? And then schools themselves would have to figure out, how do I advise our student athletes and provide them with the kind of support that Professor McCann was talking about based upon their states. And then even what rules apply to a student athlete? Is it the rules at the state where they're playing, or the rules in the state that they come from? The rules in the state that they're going to go conduct a camp in? All of that becomes highly variable, and it's one of the primary reasons we need to respond with an effective approach to all of this. Thank you for your question.
Thank you. Thank you, Madam Chair.
Yeah, thank you. Senator Rosen.
Thank you, Chair Cantwell, and I want to thank you and Ranking Member Wicker for holding this really important hearing today, and to all the witnesses for being here. You know, the Nevada State Legislature recently passed and the governor signed into law a bill that, beginning in 2022, will allow Nevada student athletes to sign endorsement deals to be compensated for the use of their name or likeness and contract with an agent. Additionally, this new law includes a provision allowing universities to require student athletes to take courses or receive training that's going to require them in contracts and financial literacy. So I know we're building upon a lot of my former colleagues, a lot of the former questions they've just had, Senator Tester and Thune, and of course, Senator Fisher. And so, Professor McCann, could this training safeguard student athletes from potential predatory contracts and help them learn and maintain money management skills that they can even use after school? And are there other ways that we can equip our student athletes with these kind of tools that they're going to need to advocate for themselves?
Well, thank you for the question, Senator. Yes, I agree. I think training the athletes and educating them on the implications of signing a contract. In law school, contracts is a whole semester course, right? It's complicated. There are many issues presented with it. To ensure that an athlete who might be 18, 19 years old knows what he or she is doing, I absolutely think advice should be provided. The tax implications that we've talked about, the fact that they may be an independent contractor to the company that they're signing with, do they know that they have to pay their taxes later, that they get paid all up front? That's not necessarily common knowledge. A lot of them may not have checking accounts and things like that. So to ensure that they're up to speed on that, similarly, the issues of immigration law, which I think need to be noted, that if an athlete is from another country, what are the implications of signing a contract on his or her visa? So I would hope that the federal bill, if there is one, contains some type of resources in place to ensuring that the athletes are educated on those issues. And it can't just be take a couple courses and go on. It has to be continuous. And maybe schools should have in place a person designated with that role to ensure that the athletes are being educated properly, to ensure that they're not taking advantage of. Because again, I know we think of agents and all of that. A lot of them are not going to have agents, and they're not going to go to a lawyer. They're going to ask a friend. They're going to ask a teammate. They're going to ask a coach, things like that. We need to be prepared to ensure that they're not taking advantage of and having checks in place.
Senator Rose, may I weigh in on this question, please?
Yes, sure, of course.
I think it's a laudable goal to want to provide support for athletes, but what I continue to hear is that we talk about players like they're second-class citizens again. We put restrictions and requirements on them that we do not put on ordinary students or ordinary citizens. If we want to encourage and provide support for players to be financially literate and the like, that is a laudable goal, and that's great. But to make it a requirement, at that point, we are saying you are different from your classmates. You are different from every other citizen in this country. You do not have the right and the capacity to freedomly contract. We have to treat you differently than your classmates. And that's a consistent theme that comes up that is an issue. We have to be really careful about being overly paternalistic about players. We can certainly provide resources and opportunities and support, but to have requirements that make them different from their fellow students is what has been going on for years and is an issue. We talk about this and talk about guardrails, for example, to protect the players. But what I'm hearing today are that the burden is being put on the players when it comes to guardrails. We have, for example, when we talk about recruiting issues and possible pay for play, we have existing recruiting rules. It's up to the NCAA to enforce those rules, to enforce them against the coaches and against the institutions that violate those rules. We've seen a number of cases where that hasn't happened. Instead, we are way more comfortable putting the burden on players and cutting back their rights and saying recruiting is going to be a problem, so we have to punish the players and we have to limit their rights. That is not a fair and appropriate way. We keep talking about having a level playing field and a level recruiting field. That does not exist currently. We know that. If you have any experience in athletics right now, we know that the richest conferences pay the most to their coaches, they have the best TV deals, and they year in and year out attract the most elite players. It is not a level playing field. NIL will have very little, if anything, to do with that. Those major conferences with the most money will continue to do the best. It might provide, NIL might provide an outsider to break through because they're in a state and they have an institution where a player who decides, you know what, I'm a quarterback in Arizona and I've got my name brand going here. There's no need for me to go to Alabama and start fresh. I'll stay here and maybe that program starts to rise. But this notion that we have a level playing field and we need to protect that is an incorrect notion. And again, I just want to reiterate, we need to be careful about being overly paternalistic and treating players like second-class citizens, and that somehow they're entitled or not capable of having the rights of their fellow students or their fellow Americans.
Thank you. I appreciate your comments. Perhaps we send up career counseling centers that people can take advantage of that if they so choose, just like we do for all kinds of other majors at universities and colleges around this country. So thank you for your time. Thank you, Chair Cantwell.
Thank you, Senator Rosen. Senator Cruz.
Thank you, Madam Chair. Dr. Emmert, as this hearing has discussed at considerable length, the states are moving very quickly to establish their own frameworks for name, image, and likeness. You state in your written testimony that, quote, conducting collegiate athletics among a patchwork of state laws is untenable. Why do you believe that we need a federal law to address this issue?
Well, thank you for the question, Senator. I think, again, this is one of the cruxes of the debate in front of us right now, obviously. There seems to be, at least among the members who have spoken, general agreement that having a singular policy at the federal level will allow all students across the country, whether they have a state law or don't have a state law, to be able to take advantage of these opportunities. Starting July 1st, there will be a dozen or so, depending on what happens in the next couple of weeks, states where student athletes will be able to go on and monetize their name, image, and likeness, and there'll be 30 or so, 35 or so that won't be able to do that. We will have a situation where schools in those other states won't be in the position to be able to recruit as effectively. The student athletes in many of these states will have very different standards that they'll have to be operating under, and the only way that we can get a reconciliation of all of that is by having a single national model.
What do you consider to be the impact on other sports? Presumably the lion's share of the revenue is going to come from the more high-profile sports, from football and basketball and sports that dominate TV coverage. What do you see as the impact of monetizing name, image, and likeness on lower profile sports, whether sports that are not covered as often on TV or women's programs at various schools?
If Senator, the policy only deals with direct name, image, and likeness and doesn't include a revenue sharing model, then I think it can have a very positive impact on women and Olympic sports, because it could provide them with greater opportunities to gain access to media markets, to be involved in any of a variety of NIL activities. Indeed, this current year we have softball going on right now. There have been some extraordinary performances that young women would be able to build upon in their social media profiles and potentially monetize. So if crafted properly, I think it could be very, very promising and very supportive of those sports. If conversely, it required a revenue sharing model that took resources away from the dominant sports that produce revenue, it could have, as a number of us have said earlier, it could have a very negative, even cataclysmic impact on Olympic sports.
So I agree with you on the importance of women's sports and girls' sports. I've got two daughters, ages 10 and 13, and my youngest daughter is an avid softball player. And I think it is wonderful, the discipline and teamwork and all of the skills that are developed through participating in athletics. I will say, Dr. Emmert, I am concerned about just how political the NCAA has gotten on the question of transgender athletes. And in particular, on April 12th of this year, the NCAA stated, quote, "The NCAA Board of Governors firmly and unequivocally supports the opportunity for transgender student athletes to compete in college sports." And the NCAA further said, "When determining where championships are held, NCAA policy directs that only locations where hosts can commit to providing an environment that is safe, healthy, and free of discrimination should be selected." That was a not remotely subtle threat, for the NCAA to target and boycott any states where legislatures are acting to protect girls' sports and women's sports. Now, it used to not be controversial to observe that there are biological differences between boys and girls, and when it comes to athletics, there can be significant physical advantages for those who are born biologically male in terms of strength and size, and that's why we have girls' sports and boys' sports and men's sports and women's sports in organized athletics. And the science continues to demonstrate that. Indeed, University of Manchester study indicated that male puberty provides a 10 to 50% physical advantage dependent on the sport, with the gap widest in activities that use muscle mass and explosive strength. Why does the NCAA think it is fair to girls or to women competing in sports to expect them to compete against individuals who were born biologically male? And is the NCAA concerned about some of the results we're seeing? For example, Connecticut high school track, where biological males are setting record after record after record in girls track and winning the championships. Is that fair to the girls and to the women who had been competing in the sports?
Senator, first of all, as you point out, this is a very challenging issue, and the member schools of the association have worked very hard to try and not make it a political issue, and rather to be aligned as closely as possible with the Olympic movement, with what goes on in the both USA Olympics and the International Olympics. So roughly about 10 years ago, maybe a little longer, the association adopted a policy that both tries to strike the balance between both an inclusive position allowing student athletes to have an opportunity to participate, but also strikes the balance with fairness. Much in agreement with what you were just saying, trying to find the fairest playing field for competition. The conclusion was that student athletes in NCAA competition who are transgendered women, for example, are allowed to compete, but only after they've been under a doctor's care for no less than a year and have had testosterone suppression treatments that have lowered their, their testosterone levels to be functionally equivalent of a woman. The cases you cite in Connecticut, while I don't know the medical circumstances of those athletes, but based on what I've read, they would not have been allowed to compete in NCAA championships. Our policies align with those of the Olympic Committee. We're also monitoring very closely and indeed working with the IOC around some of the research you cited so that we can modify as need be our policies, recognizing differences on a sport-by-sport basis. The IOC right now has instructed all the sport federations to look at extant research and other research that may need to be done to find out whether or not there can be fair competitions in individual sports because they utilize different muscle mass and, and strength skills. So we've been constantly trying to stay abreast of the science and make sure that we're striking a balance where we don't put women athletes at a disadvantage while still trying to provide an inclusive environment.
Thank you.
Thank you. Senator Blackburn.
Thank you, Madam Chairman, and thank you for the attention to this issue and for this hearing. I certainly appreciate it and appreciate that each of you are here with us today. As you heard from Senator Blumenthal a little bit earlier, this is something that we are focused on, and we are determined to find a resolution to this. Dr. Emmert, to you first. I think that it is disappointing that your Board of Governors chose not to vote on the NIL rules. And under your leadership, student athletes have been really sidelined when it comes to these issues because of an NCAA that cannot seem to make up its mind. So my question to you is simply this. Do you think it is time to call your leadership of the organization into question? Do you think you are still capable and fit to lead this organization to make a decision that is going to be fair to the student athletes and their parents?
Senator Blackburn, with all due respect, that's not a question that I need to answer. That's a question that those for whom I work need to answer. In terms of the ability of the association to make decisions, as the conversations here and in the past have demonstrated, this is a very complicated issue. And the universities have been working for now nearly 24 months trying to find an appropriate solution to come up with rules and policies that meet all of the questions that have been discussed here and all of the matters that are under consideration here. They are scheduled to vote on that before this month is over.
Okay, well, you know, the University of Tennessee has managed to figure some of this out, and the state of Tennessee has, and it's unfortunate that you're going to have, and we've had a couple of witnesses talk about the unfairness of states that have one set of rules and then another on an issue of this magnitude. But UT is deploying comprehensive NIL resources for student athletes, specifically designed NIL courses co-taught by the Haslam College of Business faculty, UT Athletics, and the College of Communication and Information. They are all working with students on NIL concepts. For the record, I'd like to get your take on this. Have you reviewed their program, and what do you think?
I'm familiar with what University of Tennessee is doing and a wide number of other schools that are preparing for the advent of supporting student athletes in many of the ways that Professor McCann was talking. I'm very enthusiastically supportive of it.
Okay. Well, Professor McCann and Professor Minton, what entity do you think should be there to oversee implementation of NIL? The NCAA has proven that they are incapable of taking up this task. So we'll start with you, Professor McCann, and then to Professor Minton.
Sure. Thank you, Senator, for the question. I think that the organization that should oversee it, the NCAA, should be a part of that. It oversees colleges. It already has systems in place. There are member institutions. I think it would be disruptive to exclude the NCAA from any role. I do think that athletes need to be part of the conversation. I think they need to be directly involved with this issue. And no matter what the entity is, whether it's a joint entity between the NCAA and something that legislation suggests, I do think athletes and former athletes need to have a direct voice.
Athletes and their parents.
Yeah, and they're adults, right? I mean, they are adults. And I think Rod comment earlier about we want to make sure that we're treating athletes the same as classmates. If you're a musician at college, you can sign a recording contract. So I think that there's something to be said for that. But I do think the NCAA needs to be a part of it, but I would say athletes do as well. That's my view.
Okay. Professor Minton?
Yeah, I think, well, certainly the NCAA, well, let's start with Congress. Congress, you know, the uniformity, I think that's a significant part of it. And requiring education. As you mentioned, you know, I applaud what has happened in your states. That's critical, and with all due respect, I do disagree with Mr. Gilmore on this point. The education and then the regulation of agents, that is empowering student athletes. There is a long history of agents disadvantaging professional athletes, so that needs to be a component of it. That, you know, the certification of agents and how they're going to be regulated, that's something best done outside by an entity other than the NCAA. But the NCAA should have some authority to sanction its member institutions that are violating the rules that hopefully Congress will establish.
Well, we agree with you, and we thought the NCAA was going to be able to step forward and set the rules, and had said to the NCAA, if you cannot do this, we will do it for you. That is the posture in which we find ourselves right now, is the inability of an organization that makes a tremendous amount of money, whose leadership is paid a tremendous amount of money, and it is all coming from these student athlete events, but yet the inability to move to a point of decision has just been an insufferable event for so many of these student athletes and their parents. This is why the states have taken it upon themselves to do what the NCAA has proven incapable of doing. So, you know, we have legislation before us. Taking an action, us taking an action may be a requirement. We certainly do think the NCAA has a role as an organization to play, but it is imperative that the leadership of this organization get the job done and not leave students in the balance, whether it is education or healthcare or NIL or any other of the various issues that you're tasked with overseeing for the health and well-being of these student athletes. Thank you, Madam Chairman.
Thank you. Senator Lee.
Thank you, Madam Chair. Dr. Emmerich, I'd like to start with you. It seems from your testimony, as well as previous reports, that the NCAA has an inclination to consider and perhaps advocate for either a partial or a complete exemption from antitrust laws. In your view, is the product that you offer, that is under the category of amateur collegiate athletics, is it so unique that it warrants the extraordinary step of either less accountability or no accountability under the antitrust laws?
Senator Lee, thank you for the question. I think first and foremost, it needs to be clarified that I have not heard anyone, I certainly haven't, and I don't know who has advocated on behalf of a total antitrust exemption. Quite the contrary. I think that the issue at hand is simply around the application of this particular NIL rule, and that the need is for the avoidance of serial litigation, either for previous actions or future actions in the application of the NIL law. Immediately upon the announcement of my Board of Governors group of 24 university presidents calling for the membership to pass an NIL law, there were immediately 2 lawsuits filed for having not done so sooner. We're trying to avoid moving toward a place where no good deed goes unpunished here. That's the only thing that's really under consideration.
Okay. All right, let's talk about compensation for a minute. I think there are some legitimate concerns out there over what might happen if you allowed for name, image, likeness compensation. For example, to whom would it go? And what questions does this raise for your member schools? For example, my alma mater, Brigham Young University, I would imagine would have some opinions about which products its athletes might endorse and from what source they'd be coming, and whether they might be endorsing products that are inconsistent with the university's religious mission. This wouldn't be limited to religious schools, though. I can imagine a lot of other schools that have that aren't necessarily religious in nature that might want to express concerns or limit the ability of its student athletes to endorse certain products. So what can you tell me about this as we approach this issue, as we have this discussion about name, image, and likeness compensation? How do we balance that ability, the institutional interest on the one hand against any individual interest on the other?
Senator, the policies that are being reviewed right now by the NCAA and have been included in many of the legislative proposals that have moved forward have tried to identify some, for want of a better term, product categories that either the law itself or institutions could indicate they don't want student-athlete endorsements in. Typically, it's about alcohol, tobacco, any substances that are considered illegal substances for athletes to consume. Sometimes it's around gambling and other participation. So there's, I would hope, an opportunity at the national level, but also at the institutional level, to make those determinations. And student athletes could then consider that in making their decisions about which institutions to attend.
How would treating an athlete as an employee of the university itself affect the university's structure? And do you think, could that also have an impact on the university's tax-exempt status?
Well, I'm certainly not a tax lawyer. I may defer to some of my lawyer friends here to answer some of that. But I think most fundamentally, Senator, converting student athletes or having them change into an employee-employer relationship fundamentally blows up college sports. The notion of collegiate athletics is that these are not employees, they're not hired professionals, they are in fact students who are participating in sports voluntarily.
So in the case of name, image, likeness compensation, would that be paid to the student athlete individually, or would it be paid to the university and held in trust? How would that work?
Yes, it's intended to all be handled directly between a third party, a sponsor, a third party entity who has no relationship with the university, expressly no relationship, and the individual athlete. The university would not be a party to that negotiation in any fashion. We also have sought to have clarity about what you're asking directly in legislation itself that clarifies that no provision in this statute would indeed convert a student athlete into an employee of the university.
Okay, can I ask one brief follow-up question? I want to make sure that I understand your answer to my first question. So you are seeking at least an antitrust exemption in part. I understand that you are not seeking it in full. Can you help me understand the uniqueness of your product and your market such that you believe you need protection from it?
Well, Senator, first of all, I don't remember which step in the three-part antitrust process that falls under, but I think the first. And again, I'm not a lawyer, and others could probably answer with more specificity. But the concern of the schools is that they may be subject to serial litigation around the implementation of the NIL rules. Indeed, we have seen already 2 suits filed against them on this issue exactly. So their concerns aren't just putative, they're real. And they want to make sure that they are not subject to that kind of litigation, again, narrowly around just the NIL rule itself.
I understand. My time's expired. Thanks for the additional time, Madam Chair. I will note that we'll need to address that issue. Because that's not, yes, that doesn't differentiate you from anyone else seeking an antitrust exemption. The possibility of litigation is something faced by everyone in the marketplace.
Yes, I understand, sir.
Thank you. It is my intention, we have one more member who is on their way here to ask a question, which I'm going to let Senator Blumenthal go ahead and ask a second round question until they arrive. But it's my hope that once Senator Scott is here, that will be the end of our members who are willing and interested in participating in today's hearing. So just to give you a little feel here for how much longer we're going to be, but I'll turn to my colleague for a second round of question.
Thank you so much, Madam Chair, and I'll yield to our Republican colleague when he arrives. You know, we have touched on this kind of elephant in the room, the nearly $20 billion in revenue that is made and generated by the blood, sweat, and tears of college athletes, and yet there are the haves and have-nots in college athletics. And I believe in sharing health costs. I think it's a path forward. Senator Booker and I have proposed a medical trust fund as a health safeguard for all student athletes, with the most profitable schools pitching in more than the less profitable ones, so that there's a use of a pool of funding to cover out-of-pocket medical expenses and the cost of long-term injuries. Dr. Fredericks knows better than anybody in this room that brain trauma, concussions may have effects well after the time that athletes are injured. And Coach Few knows better than anyone in this room about knee injuries and spinal injuries. In fact, there are about 4,000 knee injuries and 1,000 spinal injuries every year in college football alone. So we have a challenge here that we do have the money to meet. And my best information is that the media rights for March Madness alone bring in $800 million to the NCAA. So let me ask you, Coach Few, because I really appreciated the remark in your testimony that I'm quoting, schools that cannot afford to provide this care to their student athletes should be able to get assistance from the NCAA because it is the right thing to do, end quote. Would you agree that that kind of assistance ought to include helping with the long-term costs of injuries, a medical trust fund, or some way of guaranteeing fairness to student athletes in that way?
I do. I definitely believe in that. How that comes about and is set up is probably over a simple basketball coach's mind, but it's certainly something that I would champion and agree to. But I would add, as I think somebody referenced, our Commissioner Gloria Navarez's article. I mean, we do pull in a lot of money and do a lot of things, but we share most of that money within the conference and try to spread it out to all our programs that aren't, as revenue producing like ours is.
And Dr. Fredericks, would you agree with Coach Few?
Yeah, I do agree with Coach Few that revenue sharing is an opportunity to do that. But I think if we're going to look at that as well, I think, and we obviously don't have time by July 1st, but I think we need to look at things like annuities, et cetera, for college athletes as well, so that the amateur nature of what they do while they're with us, that we don't create two differential statuses. And I think to the earlier comment by Mr. Gilmore, we also want to be careful about not creating a whole infrastructure around just managing this issue for athletes that then takes away from the services that we're trying to supply for the vast majority of our campuses who do not play athletics. And I think that that's the other concern that I have about these compliance officers and all these other things that we may have to build in to manage some of these things.
Well, thank you all for your testimony. I see that Senator Scott has arrived, and I will yield to you.
Thank you. Senator Scott.
Being here.
I finished Scott, is your microphone on? Yes.
Is it working now?
Yeah, okay. Thank you.
Thanks everybody for being here, and thanks for caring about our student athletes. I finished 2 years ago as governor of Florida, and I was focused on making sure that all our kids could get a good education, they could afford it. We ended up with the second lowest tuition in the country, and according to the U.S. News and World Report, we ended up number one in higher education because we were very focused on all of our students getting jobs and getting good paying jobs. And we actually had a system, we paid our universities that way. They shared, on top of the other resources, $580 million a year, and they competed on who did the best, and that's how they got the money. So I think it's really important that our students have the opportunity to make sure they get a great degree. And we all love college sports, but I want to make sure when these students finish, not all of them are going to get to play professional sports, that they have the opportunity to get a good degree. So as you all know, Florida passed a law that is going to take effect, I think it's next month, that's going to allow our athletes to start earning compensation. It's going to ensure transparency for these agreements. It's going to guard against conflicts of interest, and it hopefully protects athletes' scholarships. Those of you that are familiar with it and have comfortable comment on it, I'd love to get your thoughts on what they've done in Florida.
Well, Senator, perhaps I could start. I am familiar with the law. We've, of course, like I think all of the panelists here, have been tracking on all these various laws for the past year or two. I think the Florida law includes almost all of the core, what I'll just call loosely the core NIL components around the ability of a student athlete to monetize his or her name, image, and likeness. It's not in that sense, dramatically inconsistent with where the NCAA rules are in many other states. I think in the Florida law, the challenge that's really quite different than other laws, as I remember it in my head, is the way it gets administered and the way it would be handled. One of the concerns about the application of the rule around fairness is to try and have an independent third entity, not the NCAA. We should not have anything to do with this. And the laws that have been, the bills that have been proposed here in this committee and elsewhere include the creation of a third-party entity to manage those relationships. It also deals with the question Senator Lee was asking. As I recall, the Florida bill has all of that transaction being conducted out of the athletic department. I think that's a challenge. It's certainly very different from the way other states envision it. Many other states don't even speak to it. It is one of the reasons we need a national standard. But the goals that I perceive of as inherent in what the Florida legislature is trying to do, I think are perfectly consistent with what we've been discussing here today and what we advocate.
Anybody else?
Yes, Senator Scott, I'll weigh in on that. One of the beautiful things about the Florida law is that it triggered the competition in nearby states to come up with their own laws so that they would not be at a recruiting disadvantage. And that triggered and spurred a lot of activity in the states surrounding Florida, particularly your Southeastern Conference programs. And I'd also like to just address the revenue sharing issue that has come up a couple of times. And while I know from talking to players that revenue sharing is something that they're strongly interested in, and that last summer the Pac-12 Players, a representative group, pursued revenue sharing from the conference, the committee probably would be well advised not to mandate revenue sharing. While it is something that occurs at the professional level, professional athletics, that involves unions and the like, I think you don't find the revenue sharing model in the business world, generally speaking. So it's difficult to push that and accept that. However, what should be allowed is the right of any conference or any school within a conference that believes it's in its own best interest to have some form of revenue sharing, whether that's in a particular sport or all sports, that should be made at the conference level or the school level. There's no need to have a mandate in the national bill saying that there will not be revenue sharing allowed. I don't think it's appropriate to have the revenue sharing at a national level to be mandated or prohibited, but at the conference level or the school level, it should be left to them to determine that. If that's what they need to be competitive in a marketplace, then that should be their choice.
How do you all think that the revenue sharing will impact our, we've got Bethune-Cookman and Florida A&M to have sports teams, and these HBCUs, how is it going to impact their ability to compete with the Florida legislation or other legislation? I guess, Dr. Frederick?
Yeah, I think there'll be a negative impact. The ability to recruit will challenge, and the smaller sports, again, I think a lot of this conversation is about football and basketball, and we appreciate that. But for instance, Florida A&M, to my knowledge, sponsors probably some 19 to 20-something sports. I don't see them being able to continue to maintain those sports without it. They actually are leaving the MEAC and joining another conference, primarily because of travel costs to some of the Northeastern schools. It's as detrimental as that. And I think this will double down on that disadvantage by not having that opportunity for them to have those opportunities.
Do you have a I'm sorry, if it's time. Do you have a proposal how you would do it differently?
I think there are a couple of things that I'm concerned about when we talk about revenue sharing. One is for some of the health costs. Again, I want to make sure the athlete is at the center of this conversation. And I think the first thing about revenue sharing we should think about is what benefits the athletes. And so having revenue sharing around health care costs, I think, is important so that we can maintain that. And then I think the secondary issues, such as maintaining the other sports, et cetera, we should look at. The other thing that we haven't discussed here today is that these are student athletes, and we must have a look at graduation rates. It's interesting that for all the conversation that we talk about, our colleges and universities are vehicles for these young men and women to get an education. And there's very little discussion about the graduation rate that should be looked at. And some of the disadvantages that have occurred have been long-standing. There's a reason why Howard is the only HBCU who's ever won a national championship. Being able to recruit athletes to win a national championship, to increase your brand, to get more resources for the bigger good of the rest of the student population just hasn't been there. And I just want to make sure that some of these laws, that as we look at them and as we look at the national law, we don't double down on that disadvantage and really ensure that an HBCU never again wins a national championship, because that's where we're heading.
Thank you. Chair Cantwell, this is a great committee. I mean, this is a great issue that we have to deal with.
Thank you.
Thanks for doing
Appreciate
this.
your bipartisanship on it. We do have one more member who joined us, I think, Senator Lujan, who I think will be our last questioner, if you are with us, Senator.
Thank you, Chair Cantwell. I very much appreciate your time today and your leadership, as well as Ranking Member Wicker. Now, look, playing college sports is a dream for so many young people, and they work hard and they sacrifice year after year. They earn their positions at these schools, and they're the backbone of these programs. So fair recognition for their work is long overdue. And I'm grateful that New Mexico has recognized this. On July 1st, my home state will be among the first to allow student athletes to be compensated for the use of their name, image, and likeliness. Student athletes are the driving force behind a $19 billion industry, yet 86% of them live under the poverty line. These numbers are shocking and unacceptable. Mr. McCann, yes or no, will protecting students' rights to the use of their name increase the health and well-being of our student athletes?
Yes, it will help them, because some will be able to generate income that they wouldn't otherwise get, and that will help their experience and make college more affordable.
The upcoming legislation puts New Mexico at the forefront on this national issue. Not only will New Mexico be among the first states to allow greater student control over their names, image, and likeness, a number of universities in New Mexico will be the first in their conference to recognize these rights. Mr. Gilmore, what impact do you expect on institutions that are the first that allow students' rights over their name, image, and likeness?
I think the impact will be very positive for those students and for the institution. I think anyone who's been involved with athletics will tell you the stories that we hear from year to year, players who are, as you mentioned, struggling financially, who have families that struggle financially, players who send part of their scholarship money back home to support their families, that these are real problems. And that for players, women included in various sports, who will have an opportunity to have additional income to support themselves in college or to help their families, it's going to be a huge boon for them, and will be a very, very favorable thing for those universities that take that step.
Appreciate that. Now I have a simple yes or no for the panel, and I'll start with you, Coach Few. Thanks for being with us today. Yes or no, should every student athlete have a right to earn money from their name, image, and likeness?
Yes.
Dr. Emmert?
Yes.
Mr. Gilmore?
Yes.
Dr. Frederick?
Yes.
Mr. McCann?
Yes.
And Mr. Minton?
Yes.
Now, given that, I have one question to ask. Why did it take so long? We've been having this argument for over a decade. It's common sense. Coaches have been making millions of dollars while students are making nothing. Dr. Emmert, can you answer that?
Yeah, I've addressed that a couple of times already, Senator. It's a very challenging topic, obviously. The NCAA rules are all made by the schools themselves through a representative body that functions very much like Congress does. They have been debating, discussing this, and working toward this moment for at least 3 years now. And it is a very complicated subject. Coming up with the general consensus about what the outcome should be has been relatively easy. Getting people to agree on the details of it has been extraordinarily complex, but I'm very hopeful that we finally have the schools at a place right now where they're ready to pass a national standard. That, however, will not alleviate the need for federal legislation because New Mexico and others have moved forward and passed laws that I think you and I would agree are very positive. They also are very different in the way this is being described around the country, and most everyone agrees that we need a single national standard rather than 50 different rules, and that's why we're here today, I hope.
And one last question to Mr. Gilmore. Athletes from New Mexico are competing at the highest level across a variety of sports. In fact, the NCAA Division I Track and Field Championships are starting today with a number of New Mexico's athletes competing there in the high jump, 5,000 meters, and the steeplechase. And they've worked hard to get there, and I wish them all luck and hope that they bring back the gold from all these events. Now, Mr. Gilmore, how do we ensure that new legislation addresses the needs of all student athletes across all sports?
Well, I think part of the immediate response to that is just likely beneficiaries of NIL will be women athletes in other sports. They may be some of the most popular on campus and through social media. So this is going to benefit athletes across sports, not just football and basketball players. And that is one of the real reasons why it's really important to have it. And New Mexico has taken that step already.
Appreciate that as well. And I yield back, Chair Cantwell. Thank you again for the time.
Yes, thank you. Well, I do want to thank everybody for participating. And to that point, Mr. Gilmore's point, we are going to have a panel in the future that will include a panel of athletes so that we can hear their illumination of the healthcare, scholarship, standards, and education issues. So that concludes our hearing for today. Again, thank all the witnesses, both in person and virtually, for this. I want to thank my colleagues. I think, as you can see, my colleagues are ready to dig in. They gave this hearing. More than half of them participated in this, and that is a lot for the United States Senate to be as active on this policy. So you can see the determination. We're determined to get this done. So your testimony today helped move this ball down the road for us to do that. I probably agree with many of the things that, that Coach Few and Senator Blackburn said. I wish we weren't here, wish we weren't having to deal with this, but we are going to make sure that this issue is addressed. So again, thank you for all the illumination today. There is any senators who would like to submit questions for the record, if they can do so within 2 weeks by June 23rd, 2021. So with that, the